Hello, everybody. It's me, the Grouchy Historian. That's right, wearing my super cool summer shirt because it's summer and we are racing to get the rest of these videos done. So let's go along and start with the third quarter, week 2. Okay, this week we start looking at a selected number of Supreme Court cases, right? So for the rest of this quarter up until your final, every week we're going to look at a group of Supreme Court cases that deal with a particular issue, right? They're all the same court case, or they're all court cases over a sometimes extended period of time that all relate to a certain topic. So here's what I want you to do for your paper each week, right? What you're going to do is you're going to, as it says in your syllabus, briefly outline what the cases, the constitutional issues that the cases dealt with, right? It's typically one issue, but there may be a couple of issues, right? So outline the constitutional issues that the cases dealt with, synthesize the court's opinions, right? So again, you may have a series of court cases over a number of years or even decades. What I want you to do is synthesize what the court said, right? How it ruled on the constitutionality of the particular issue that was raised in the case. And most importantly, and this is where we're going to kind of dig into these a little bit, is why are these cases still relevant today, right? We're going to start with some of the earliest Supreme Court cases and go down to, I've picked a number of cases that have been decided within the last 50 years, right? Starting with Roe versus Wade for obvious reasons, but there's a lot of very recent court cases that have had a significant impact on American society and how we live. Yes, how we live. So the whole purpose of this quarter is to look at sort of the practical real life implications of the Constitution in the context of Supreme Court cases and how it deals with a number of issues. As I said, as we looked at in the second quarter toward the end, looking at the Constitution, particularly in the Bill of Rights, there are still court cases every year dealing with one or more of the amendments in the Bill of Rights. As I said, in the week that we looked at the Bill of Rights, particularly the First, Second, Fourth, and Sixth Amendment, okay? So this week we're gonna start at the beginning, the very first significant court cases that the Supreme Court dealt with. And there's two of them that we're looking at this week, Marbury versus Madison and McCulloch versus Maryland. Now, some of you may have heard of Marbury versus Madison, and we're going to talk about that a little bit, but we're also going to put a little extra spin on it because for anybody who hopefully has read this awesome book, The Words That Made Us, from one of my favorite books this year so far, he has a pretty unique spin on Marbury versus Madison that I had never heard before, but it makes, like a good chunk of the book, it makes a lot of sense to me. So let's start with Marbury versus Madison. So the important thing you have to remember is that this is the era when these two court cases were adjudicated, the era of Chief Justice John Marshall. Now, John Marshall was one of the founders, and he was probably the most significant Chief Justice that we've ever had. Every Supreme Court Chief Justice since him has been compared to him. And let's be honest, most of them have fallen far short, okay? But one of the things you have to know about Chief Justice John Marshall, as I say here, is he's both a legal and a political genius. If you remember, in the Constitution, the article dealing with the judiciary was the most vague, right? All it said was we're going to establish a Supreme Court of some number of justices and certain other courts that the Congress may see fit to create, right? So there was not this, our modern court structure where you had federal district courts, federal circuit courts leading up to the Supreme Court. All of that came about as a result of legislative action after the Constitution was ratified. So John Marshall, as not the first Supreme Court Chief Justice, but the most significant early Supreme Court Chief Justice, had to, in some of these early rulings, thread a very fine set of needles, to use a sewing analogy, because he was very aware, like all of our founders were at the beginning of our country, that the actions that he took as one of the first Supreme Court justices would affect the country for all time. All of our founders were very, very aware of this. And it did indeed, as if you read the writings of George Washington, affect how they thought, because they knew that basically they were being watched by their countrymen, and they expected that their countrymen and their countrymen's children and grandchildren and great-grandchildren, et cetera, would judge them by what they did. So John Marshall was both a political and a legal genius, and he was very good at asserting the independence of the court without going too far and precipitating legislative action, so to speak. So we start with the court case of Marbury versus Madison. Now, most of you who studied AP government or may have studied government before say that this is the court that established the concept of judicial review, and that is correct. Most legal scholars would say that Marbury versus Madison, which is actually a pretty innocuous case once you dig into it, is one of those federal civil servant spats. But, and of course, Marshall, the way that Marshall did his ruling was very narrowly focused, but it had a lot of ramifications, right? So what Marshall basically what the point he wanted to get across is that the Supreme Court, or is that the Constitution had to be the supreme law of the land, and had to be more importantly, the fundamental law of the land, right? So if you get in dispute about which law you should follow, which law should take precedence in a particular situation, his point with Marbury versus Madison is you always go back to the foundation of everything, which is the Constitution. But the actual ruling at the time was not considered very significant, but because of the concept of judicial precedence, and precedence being the basis of most American and Western jurisprudence, we will see that even today, Marbury versus Madison, the idea of judicial review to determine the constitutionality of a duly passed legislative action called a law, right? Or even an executive action, all goes back to Marbury versus Madison. Now, on top of that, you have a case called McCulloch versus Maryland. Now, this is the one that you may not have heard of, but it goes kind of with Marbury versus Madison. And this was a case, again, dealing with taxes and banking and finance. Shocking, we'll see a whole lot of Supreme Court cases that deal with taxes and banking and finance. Not shocking at all, actually. But the end result of McCulloch versus Maryland is the idea that the Constitution was indeed the supreme law of the land, right? States' actions, state laws could not override the Constitution. And we see this even today, right? If you go back again to the Bill of Rights, Article 10 of the Bill of Rights very specifically says that anything that is not specifically delegated to the legislative and or the executive branch by the Constitution is reserved to the states. Now, one would think that that's pretty clear cut, and certainly our founders intended to be clear cut, but it is not as clear cut as it would like to be, because of course we have this gigantic federal government that has severely overdone, I think, the necessary and proper clause, right? We talked about that when we examined the legislative branch. The interpretation by the courts and the Congress of the necessary and proper clause has pretty much led to everything the federal government has done in the last 100 years. There's still that tension between what is considered a responsibility and role of the state and what is considered a responsibility and role of the federal government. So the idea that this Constitution was indeed the supreme law of the land was a very important precedent, there's that word again, to set early on, that the federal government was indeed the national government that was over the state governments, except for, again, very few things that were outlined in the Constitution. And there are things in the Constitution that are outlined as specific state responsibilities as well. There's always that gray area in the middle of what is the responsibility of the state versus the federal government, right? So Marbury versus Madison and McCulloch versus Maryland are the first two cases we're going to look at that sort of lay out exactly where the federal government ends and the state and local governments begin. And this sort of boundary between them is ever evolving, even to today. There are court cases that come up where the states want to do certain things. that the federal government may sue them because they think it's their responsibility, and vice versa, that end up in front of the Supreme Court to adjudicate. So as you read these two cases this week and look over the opinions, I urge you to think about the concept of judicial precedent and how these two cases that were decided in 1803 and 1829, over 200 years ago, or almost 200 years ago, as the case may be, still affect us today. Okay. All right. Looking forward to, I'm sure your instructors are looking forward to your papers. So we'll see you next week.